Saloni, you
Okay,
can.
guys, before we start, don't need to seek permission for anything, just go with the flow. Okay. And
Okay, sir.
even if you say sir, it's completely fine, but my lordship, your lord, something will be okay, acceptable.
Okay. Uh,
Hmm.
so before we begin, would you like us to go into the facts on the jurisdiction, or do we just start from the issues?
No, no, facts and jurisdiction, yes.
Okay, fine. Uh, so maybe begin.
Yes, please.
Um, May it please this honorable court, I appear on behalf of the appellants, the AVC Bank. I shall address issues 1 and 2, and my co-counsel shall address issues 3 and 4.
Okay.
Your Lordships, at the outset, it is respectfully submitted that this Honourable Court possesses the jurisdiction under Section 62 of the IBC 2016, which authorizes an appeal from an order of the NCLAT on any question of law. The present appeal raises pure questions of law regarding the maintainability, the scope of Section 10A, the application of res judicata, and the statutory nature of the code itself. Hence, the court's jurisdiction is unequivocally unattracted. A brief facts before we proceed into the issues. The ABC Bank advanced a 500 rupee crore credit facility to the respondent. The respondents eventually ceased, and the loan account was classified as an NPA on the 1st of April 2014. Between April 2014 and 2022, the corporate debtor repeatedly acknowledged its liability in writing through restructuring requests, revised proposals, and ODS letters. At the first Section 7 application was filed in 2022, which relied on the 2020 OTS default and was dismissed solely under Section 10A without touching upon the merits of the case. A second application was filed in 2024, which relied on the correct operative default of 2014, which was duly received through acknowledgements. Both the NCLT and the NCLAT rejected it, alleging whimsical alteration of dates and res judicata. This appeal is now to challenge those conclusions. That being said, I would like to proceed with issue 1, which is the question as to whether the second Section 7 application is barred by law. My lord, it is humbly submitted that res judicata requires an earlier matter to be heard and finally decided on merits under Section 11 of the CPC. Here, the earlier petition was dismissed only because Section 10A statutorily prohibited admission, but no adjudication took place on the grounds of debt, default, limitation, acknowledgement, or liability. In the case of Neelkant Township and Construction Private Limited, this honorable court held that rejection of an application without entering into adjudication on merits does not bar a fresh application. The 2022 dismissal was a pure procedural allegation and not a judicial determination of the rights and facts of the appellant. There was no judicial mind was applied, there were no merits weighed, and neither were any rights adjudicated upon. Thus, res judicata itself cannot be imported by a metaphor or imagination, and the doctrine itself collapses at the gate. Therefore, the second appeal should be allowed. Secondly, my lord, Section 10A is not a shield. Your lordship, Section 10A was a pandemic time suspension that was limited to that time period due to COVID and due to the tumultuous circumstances of the time. This is not a merits-based pronouncement. In the case of Ramesh Kamyal versus Siemens, this honorable court itself held that Section 10A only bars limitations of the CIRP for defaults within the protected window of time. It does not extinguish the rights of the parties, it does not adjudicate the debt, and neither does it foreclose future petitions that are based on earlier defaults.
Can you share the judgment, please?
The Ramesh Kamyal judgment. Yes, sir. Can I?
I think you can screen share.
Screen share the judgment? Yes, my lord. My researcher will be presenting it on her screen.
Okay. Continue in the meantime.
Yes. It does not, my lord, it was essentially said in this case that Section 10A cannot be interpreted to extinguish the debt or take away vested rights of the parties. In
But
other
that
words,
case
we
could have gone
contend.
to DRT, no?
Beg your pardon?
There's a reason the Section 10A was brought in.
Yes, my
That does
lord.
not extinguish your right, but it extinguishes your right towards for NCLT proceedings. You could have definitely gone for DRT proceedings, other recovery mechanisms.
Um, My lord, at the time that section was put in with regard to COVID, we did not file it because of COVID happening. We filed it because there was a failure on their part to pay the debt.
No, but date of default is sacrosanct when it comes to IBC proceedings, especially with Section 7, right?
Yes, my lord.
There's a reason the form is made in such a way when you file a case, the form has a specific date of default. If your date of default lies on the date in which the section 10A was applicable, that means your case should not have been entertained at all, which is rightfully done by NCLT and NCLAT both.
But my lord, we did the date of default was technically section 14. So we did go ahead to change that to address that it was section 14. And there are cases that do accept this change of dates, which we address in the second issue.
So you should have amended it then, no?
Yes, my lord, we did amend it through a second petition.
No, there's a process of amending the first petition itself. Because 10A was applicable on your case, you could have simply amended the first petition.
My lord, when we did go to amend the dates in the second petition, the NCLT and the NCLAT did not permit us to do the same, and they rejected our petitions. Therefore, we are approaching the Honorable Supreme Court to let us amend the dates in this matter.
Okay. Can you show me the substantive part of this judgment?
Yes, my
This
lord.
is Kamyal, right?
My lord, it's open on the screen itself.
What are the facts of this case?
Uh,
Speaker
one
one, what are the
second.
facts of this case which you're referring to?
1 second, my lord. I shall provide you the same. My lord, this case was Mr. Ramesh Kamyar was the former chairman and managing director of Siemens Gamesa in India for Indian operations, and he
Hmm.
resigned in January 2020. He
Hmm.
claimed the company owed him a settlement of 104 crores.
Hmm.
So there was a default on the part, and therefore he filed this petition under Section 9 of the IBC.
But this is Section 9 judgment, right?
Yes, my lord, but they did go into the matter of discussing Section 10A
If,
suits
if you
because it was
resigned
filed
in,
during
if you,
COVID.
if you resigned in January, how's the date of default under Section 10A?
He
The,
claimed that the date of default of the money they owed him was prior to the COVID dates. That
okay.
the Section 10A did apply from March of 2020, but
Yes.
the default that happened towards him was
Hmm.
prior to that. And he
Yes.
filed the petition 1 month after Section 10A was introduced. So
So
the
February he
default,
filed it.
yes, my lord.
And why was the matter rejected from NCLT and NCLAT?
Because they were trying to apply Section 10A on this when he claimed that the dates of default were existing prior to that.
No, was his application allowed in section was in NCLT and NCLAT?
No, my lord, it wasn't, so it was taken to a higher court.
What are the grounds for not allowing it?
Um, because they applied Section 10A, which barred the filing of new applications for initiating the CIRP for any default that occurred on or after March 25th of 2020.
Okay.
That was the grounds, and
Can
that is
you,
why he took
can
it
you
to
go to
the
the
Supreme Court.
substantive, the fact part where his application was rejected? I think
Uh,
it'll be in the next page.
1 second, my lord. Just go up
File
to
an app. No,
facts.
just be here. Just be here.
My lord, you would like me to go to the facts of the case, or would you like to go
No,
to
no,
the
just the part where his application was rejected by NCLT and NCLAT.
1 second, my lord.
It
One
was
second.
on the page which you were earlier sharing.
Which differ? What did you? Mm.
Just hold on.
See, if you see, my lord, the NCLT upheld the submission of the respondent,
Mm-hmm.
not of the applicant, who was Mr. Ramesh Kamyal in this present matter.
And what is the ratio of the judgment?
Um, what is it? My lord, counsel seeks ignorance as to the ratio of the judgment, but if you would provide counsel with second, counsel can provide that information to you.
No, just go to the first paragraph.
Yes, my lord.
No, there's no summary of it. Okay, moving on. Continue.
Thank you, my lord. Therefore, my lord, based on this case itself, we can contend that Section 10A is an embargo and not a decision, and thus the final dismissal mandated entirely by 10A cannot remove the res judicata bar. Cannot imply a res judicata bar.
Any judgments supporting this
Uh,
directly that
we are
second?
relying on the Ramesh Kamyal as of now, but we are going to recognize the judgment under the Dina Bank case, which was another landmark judgment in this regard.
What is the Dana Bank case?
It deals with the with occurrence of a default for purposes of Section 10, Section 7.
No, no. Tell me in a case where, tell me facts of a case in which, or citations in which first application was rejected.
In
and
which?
in which the first application filed by a bank or a financial creditor was rejected, and then the financial creditor filed a second NCLT application.
My lord, in the Dina Bank case, what had happened was the primary legal question was whether a financial creditor could file an application under Section 7 of the IBC based on a prior court judgment, decree, or recovery certificate, even if the original loan default occurred more than 3 years ago. And that at that time, the NCRT had previously ruled that it was time barred. So then they filed a second one, and that was allowed.
See, your case is not that it's time barred. No, your case is that the first appeal, the first Section 7, which was filed by the bank, was dismissed solely basis Section 10.
Yes, my lord.
Then you filed a second Section 7 by
Hmm.
changing the date of default.
My lord, if the case does say time barred, the Dina Bank case, but there was a first petition filed that
Hmm.
was rejected, and then
Hmm.
they took it for a second petition, which was allowed later.
Can
And
you show me the facts of that case?
yes, my lord. Can you please open DI Pass? Thank you.
To second team also, please keep your citations ready for sharing. I'd like to go through them.
My lord, can you see the judgment? It is being shared.
Yes.
Yes.
This is
This is the Dina Bank case.
okay. Continue scrolling at a slow pace so I can read through this. Next line, please. Okay, next. Next. Mm. Moving on. Next, please. Hold it here, please. Please.
Hold it here. Um, My lord, speaker one has 3 minutes left, and we do have one more issue to address. So may the time either be paused, or
I
we
think it
can
matters. Don't worry
request.
about it.
Okay, thank you. Much obliged, Your
Courtmaster,
Lordship.
if I'm reading, going through the judgments, you may hold the time. But that's not how it generally works in court, but we'll hold it for now. Next, please.
Thank you. Scroll. Hmm.
Para 21, please.
Yeah. Hmm. Hmm. Hmm.
That is, I don't see that to be the case. You told me there are two applications. Just hold this. Speaker one, you told me that the first application was rejected and then the appellant bank filed the bank filed another application, right?
Hmm. Yes, my lord.
Which paragraph says so?
1 second, my lord. Uh, Give me the judgment. Look at this. My lord, they were allowed to file the second thing, the second
Which
petition.
paragraph? Can you point out the paragraph?
Yes, my lord. 1 second. My Lord Counsel realizes that she messed up the facts of the case. Much apologies.
Hmm. That's what I was wondering because I've gone through
Mm.
this case before. So, speaker one, I think, see, what you have to realize is res judicata means that once you have already filed an application, it has been rejected, you can't go back to the same court under the same application. These cases are not that.
Okay.
This is related to limitation rather, and whether I don't even know how it's applied in your case. So moving on to the second issue, then you have less time now.
Yes, my Lord. So, my Lord, in the second issue, we are mentioning it is whether mentioning the exact date of default is mandatory in a Section 7 application. Your Lordship, it is humbly submitted that while the date of default must ordinarily be indicated, its imperfect articulation can never defect a petition where debt and default are otherwise conclusively established. The code simply does not permit a technicality to triumph over a decade-long undisputed financial dispute or default in this case. So under
Any
section
judgment
3,
supporting this?
my lord, we will go into that while we argue the matter. And we will
Okay.
also present them a judgment if it would
Be
be
ready
suitable.
for presenting the judgments, yes.
Yes. Innovative industries. So then under section 12, under section 3, subsection 12 of IBC, it defines default as the non-payment of debt when it has become due and unpayable and has not been paid by the corporate debtor. Thus, the statutory anchor is the fact of non-payment, not the phrasing of the date. So the fact that there has been a default is more important. The moment payment becomes due and remains unpaid, the default crystallizes. The quote in the case of Innovative Industries Limited, which will be shared on the screen versus the ICICI Bank, made this, in a sense, crystallize this argument. The Honorable Court held that the adjudicating authority's inquiry is strictly confined to verifying existence of a financial debt, occurrence of a default, and completeness of the application. Nothing in the case nor in the code elevates the precise perfection of the date in the condition present.
Have you
The
seen the Section
case,
7 petition, Speaker 1?
beg your pardon,
Have you seen the Section 7 petition? There's a specific form that needs to be filled.
Form 1, my lord.
Yes, the form has a very specific entry for date of default.
Yes, my lord.
So
But
completeness
we are
of
addressing the
entry,
fact that the more relevant part of it is the fact that there is a default. This is not a small matter, my lord. This is 500 crores we're talking about. Uh,
500 crores, that is immaterial from NCLT perspective. But the fact remains that the form in which you have to fill while filing a Section 7, there's a reason it has been made in such a manner.
My lord, there has been a record of the fact that there are multiple that there has been a default. There are multiple communications based on this. Even the other party has acknowledged their default.
See,
Therefore,
counsel, nobody is denying that debt and default are only two things that needs to be proved in a summary suit like this. There's no need to lead evidence on other issues. But the form being very clear on a specific date of default, and the Section 10A amendment also brought in for a specific reason that the date of default is material to adjudicate on Section 7s.
my lord, if we look at section 7, subclause 3, the financial credit, it says that the financial creditor shall, along with the application, furnish record of the default recorded with the information utility or such other record of evidence of default as may be specified. Therefore, we have that there is a record, this information has been provided, and therefore that the date is being as important it is, there is more evidence as to the fact that the default did occur on the 14th in 2014, not in 2020.
Any specific judgments with regards to date of default not being important because innovative is more holistic in nature in terms of debt and default definition of what a debt and default is to do. Anything
Okay.
very specific with regards to the date of default not being very important for Section 7 adjudications.
1 second, my lord.
Or you can save it for the rejoinder part.
Absolutely, my lord.
So the time is up.
Yes, ma'am. Much
Speaker 2.
obliged.
You can
Much
start.
obliged, your lordship.
Speaker number 2.
May it pleases your lordship, the speaker number 2 would like to proceed with the issue number 3.
Yes, please.
So, your lordship, the issue number 3 is whether the date of default changes based on circumstances or is it to be treated as the non-performing asset state in bank matters. Now, Your Lordship, when we look at Section 3, Subclause 12 of IBC, it defines default as a non-payment of debt that becomes due and remains unpaid. In the context of banks, the moment that failure occurs and continues in uninterrupted manner for 90 days, the RBI norms compel the creditor to classify these accounts as non-performing assets. Now, this classification is not discretionary, Your Lordship. It is not internal or accidental. It is actually a statutory recognition by the RBI to state that the borrower has failed to honor its obligations, Your Lordship. Now, the position is now authoritatively settled. Even when you look at the case as previously mentioned, Dina Bank versus Shivkumar Reddy, the Honorable Court classifies that NPA classification marks the occurrence of debt for the purposes of Section 7. So now NPA classifies the very first instance where there is an inconvertible indication that the dues have not been paid when they were to be paid. Now, Your Lordship, in our case, the accounts became NPA as early as 2014, Your Lordship, and that is the earliest proven date as for the default, which is very well proven in the statement of facts. Now, these subsequent events cannot shift this default. The borrowers can commonly engage in one-time settlement proposals or restructuring requests or even fresh repayment payments. But none of these create a new date of default, Your Lordship. These are all continuous of an existing liability. They do not cause a new cause of action, but only validate and acknowledge the original default and attempt to settle the original default and the consequences of that default. Now, each post-default communication was treated as an altering date of your default. Your Lordship, the insolvency trigger under Section 7 would become fluid and manipulative and uncertain, entirely dependent on a debtor strategy if in case we were to assume that the date of default could be changed as per the subsequent acknowledgements, which shall not be the case, Your Lordship. This is precisely why in the case of Innovative Industries versus ICICI Bank, the Honorable Court made it abundantly clear that the moment the debt occurs, the financial creditor has a right to file under Section 7. And in our present case, the very first minute the debt occurred and was statutorily recognized was in 2014, Your Lordship, which is well before the statutory temporary period of 10 days. Now, Your Lordship, there's a critical distinction is critical and directly applicable to a present case. That is, acknowledgements revive limitations, but they do not change the default itself. So this also harmonizes with the SARFSC jurisprudence, where all enforcement rights mature only after NPA classification. This is again confirming industry-wise recognition that NPA simply means legally recognized default. So, Your Lordship, in the case of Axis Bank versus Yashwant Durg Pariyaka, expressly held that creditor may clarify the date of default to reflect the correct position. Now, Your Lordship, as you're asking my co-counsel, the case where Honorable Court held that date of default can be corrected in case there's material evidence for such correction. This particular case allowed such correction and said that this correction does not introduce a new cause of action simply because the default is a continuing fact and not a single point of fact. So in our present case, the default has been continuing since 2014, Your Lordship. Thus, the default. Yes, Your Lordship. I will request my researcher to share the judgment.
Researchers that automatically just continue sharing the judgments that the issue is covering. Can you repeat again with regards to your issue number 2? You are saying, just a second, that your NPA is the date of default and not
Yes,
the
Your Lordship.
1st of May 2020 letter by the finance.
Yes, Your Lordship. That's exactly why the council seek to amend such date in the present petition in front of the Honorable Supreme Court.
Understood. Now, the judgment which you are sharing, what are the facts of
Your Lordship, until my researcher finds the document, if you would permit, I would explain you the facts of this case.
Yes, please.
So, Your Lordship, in Axis Bank filed the application under Section 7 before the NCLT Mumbai bench, alleging that there was a default by the corporate debtor on its loan facilities and it seeked for CIRP. So now the Section 7 petition initially mentioned the date of default as 1st May 2020. Later on, after examining its records, Axis Bank realized that the correct date of default was actually 1st February of 2020. That was 3 months earlier than the date of default that they had initially submitted.
What was the basis of that? What document did they rely upon for claiming that the date of default is not 1st of May but 1st of Feb?
Just a minute, Your Lordship.
Registrar may, Master, may please pause the time when she starts showing the judgment. The researcher, you're on mute if you're trying to talk. Speaker number 2, do you have anything to add?
Yes, Your Lordship, I'm so sorry. I'm searching the exact documents that they refer to change this default. As
That is
of now,
material, no? To adjudicate on the basis of which.
yeah. So actually the loan statements of the corporate debtor was shown that the earliest date of default was on 2020. They had actually referred to their bank balance and loan statements of the corporate debtor, Your Lordship.
Okay. Please share the judgment, researcher.
My lord, the researcher's having an issue with sharing her screen. She's trying to, but it's not permitting her.
Can you share? You were able to share right now, right?
I was, my apologies for speaking, sir, but I was, and now I'm trying and it's
You
not
have the right
letting
to
me.
speak. Please continue. Please.
I'm so sorry. Yes, I've been trying for the past 5 minutes and it's not, I'm just trying to get it done.
Okay. Okay, can you just give me the citation? I'll check on my own.
Give you the citation.
Yes.
Are you giving it? I'm so sorry. Go ahead.
Speaker 2, please go ahead and give the citation.
NCLT Bench 2022 IAIBC 1382 MB 2023.
Oh, sorry. Slow. 1382.
Sorry. 1382 MB 2023.
2023. Okay, I'll have a look at it.
Yeah.
Okay, moving on.
Your Lordship, I will also continue with the particular facts of this case. So once they realized the loan statements and the bank statements actually indicated the debt was 3 months earlier. That was on February 2020. After that, the corporate debtor filed their replies and formally recorded as complete. And however, the NCLT found that just noted that underlying loan transactions and default itself were never in dispute. The evidence on record were already reflected the earlier date and held that this amendment did not introduce any new claim or any new cause of action but merely corrected an inadvertent error. So, Your Lordship, now in the present case, the underlying default on the behalf of corporate debtor is not an issue, not challenged here. All the acknowledgements and the OTC settlements were failed and were failed to comply upon by the corporate debtor. The financial creditor has been continuously trying to give any sort of opportunities for the corporate debtor to actually repay the creditor. However, that all of those opportunities were failed by the were not used by the corporate debtor. So now in the present case, the NCLT bank itself said that when there is a default, the existing of default is present and the default dispute is undisputed, the default is undisputed, such cases should not be dismissed merely because there is an advertent error in the date of default, which is exactly in the present situation. There was simply an error on the consul's behalf on the date of default, and once we went through all of our documents and realized the NPA was much before 2020, it was in 2014. The amendment, we proceeded to amend such date.
So, the case that you are referring to, in that case, the Section 7 application was amended, right?
Yes, Your Lordship.
In your case, it was rejected because you made no such attempts to amend the petition. And second, you filed a fresh petition after dismissal of the main petition.
The petition, however, Your Lordship, was dismissed without considering its merits, because in the present in the previous petition also the dispute regarding the default were undisputed and they weren't considered by the Honorable NCLT court, because the dispute in the present case was 500 crores and all the acknowledgements and the OTC settlements and agreements between the corporate debtor and the financial creditor throughout from year 2014 to 2022, Your Lordship, acknowledged that this debt was indeed existing and was prolonging and was continuing throughout these periods. However, these material facts were indeed failed upon to be considered by the NCLT court, which is exactly why we had to file for a fresh petition with the amended date. Therefore, this dispute can be resolved, Your Lordship.
Okay. Moving on to the next one. Researcher, have you been able to share the judgment by any chance? It's okay. Moving.
Already, Your Lordship, I would proceed with the issue number 4.
Yes.
The issue 4 discusses whether the Section 7 application can be admitted or established despite an error in the pleader default date. Now, Your Lordship, the substantive financial default for over 500 crores can be rendered irrelevant. They cannot be rendered irrelevant simply because there was a technical or clerical error in stating the default date, Your Lordship. Section 7 petition cannot be dismissed on the basis of misdescription of the date of default if the debt and the default and the limitation are independently and conclusively established on record. The principle springs from the very architecture of the code, Your Lordship. The scope of inquiry under Section 7 is extremely narrow. The Honorable Court in the innovative industries laid on threefold test for this. Firstly, is there a financial debt? Does the financial debt exist? And if the debt exists, has a default occurred? And once the default occurred, is the application complete? Your Lordship, certainly not penalizing a creditor for an inadvertent error which is immaterial to actual facts. This position was also reaffirmed in E.S. Krishnamurthy case. That IBC is not a forum for technical objections. The AA must confine itself to verifying the documents and occurrence of the default. So, Your Lordship, if the materials demonstrate a clear and admitted continuing default, as they do here, the petition has to be admitted, Your Lordship. Correcting a default date does not create a new cause of action. It's simply the cause of action was original and existing since the beginning of the NPA date, Your Lordship. As I meant, like we already discussed, the Axis Bank, it said that the real date can be inferred from the record, and the NPA date is a logical foundation of the default. This aligns perfectly with the court's objective for resolving insolvency rather than encouraging procedural gamesmanship, Your Lordship. And furthermore, Your Lordship, the council would also like to emphasize that all of these acknowledgements from the year of 2014 to 2022 very well kept the limitation period alive, irrespective of any earlier error, as under Section 18, Your Lordship.
Can you tell me which paragraphs of innovative judgment are you relying upon? Speaker 2.
Just a minute, Your Lordship, I will tell you. Innovative judgment.
Charles.
No, you don't need to share your screen. Just tell me the paragraphs. But okay, now that you have shared, just let me.
Researcher, can you scroll up to paragraph 28?
Can you repeat what were you referring to in innovative?
Yes, Your Lordship. I stated in innovative industries versus IC Bank, the court made it clear that the moment the default occurs, the financial creditor has a right to file under Section 7. Furthermore, I also stated that
The part thereafter.
the part thereafter, I said they had a threefold test for admission. Firstly, whether there's a financial debt and has a default occurred, and if the default occurred, is the application complete?
Yes. So in your case, was the application complete?
We had a right to file an application, Your Lordship. However, that application was dismissed without considering its merits. Which is
Counsel,
precisely why.
no, counsel, your case was discussed on merits. It was dismissed on merits because a certain amendment was made specifically to safeguard companies that were going insolvent under that period. The date of default falling within that period. That being said, your application was complete in all sense because you relying on 0105 as the date of default was for a very specific reason that you had recalled. It was not the other way around. But if I look at the facts on 1st of May, just a sec. 1st of May 2020, you issued a letter to the corporate debtor cancelling the OTS sanction. Okay. So your date of default is fixed. Of course, you did not time it accordingly that the 6-month exemption could have applied. You could have done it post the 6 month. But you doing the same is the date of default. Now, it has been decided, your application, your NCLT app, the first one was decided on merits because the merit itself was at Section 10 exemption given to this company. And all companies where date of default was in that period. So the claim that this was not decided on merits itself is wrong. Now comes the part that there was an error in the date of default. What you need to prove to me is that your 3 and 4 are in fact combined, that there was no error in the that there was no error in the date of default, but you have the right to change the date of default.
Yes, Your Lordship, which is what the council is trying to state that although we had initially chosen a different date, once we went to a
Your voice got disconnected, speaker.
did not permit us to do such amendment, which is why we had to file a fresh petition under the Honorable Supreme Court.
Your facts are silent, no, on whether you actually tried to amend or not. That is something that it's okay, it's not covered under the line. Chalo. Moving on. Yes, please. Closing arguments, I believe, Court Master.
The speaker too has a minute and 10 seconds left.
Go ahead.
Yeah, okay.
Include this, please.
Yeah, yes, Your Lordship. So furthermore, Your Lordship, I would also like to state that even in the case of Swiss ribbons, the Honorable Court declared that IBC is a beneficial and remedial legislation where substance prevails over form. Technicalities shouldn't be allowed to defect a legitimate insolvency proceeding, especially not where the debt is undisputed and the default is overwhelming, Your Lordship. And the limitation is revived up to the year 2022, Your Lordship. Denying admission merely because of an error in stating of default date would be irrelevant from the substance, something that court expressly prohibits, Your Lordship. With this, the council would like to proceed with the prayers, Your Lordship.
I have a last question. You can skip the prayer part. So tell me something. In your first loan was given in 2013, right?
Yes, Your Lordship.
And then 2014 you defaulted, and 2022 is when you filed the first Section 7 application. And after it was dismissed, you filed a secondary one. What I know the letters are there, 1 to 9. But any judgment will support that you basis these letters, the date of default keeps getting extended.
Yes, Your Lordship. Your Lordship, in the case of Kodabenya Srinivas Krishna versus PVM Investments Private Limited, the facts concerned was limitation and acknowledgement in the context of operational death and subsequent proceeding. The judgment held that recognizes that where a matter is real and factual default and subsequent acknowledgements are present, a fresh cause of action and it's continued from these acknowledgements. And furthermore, there are a few
Show me
other
the relevant
cases, Your
part, please.
Lordship.
Show me the relevant part. Just the ratio of this.
Just a minute, Your Lordship.
Speaker number 2, will it take some time?
Yes, Your Lordship, the council seeks ignorance as the council is unable to find the relevant part of this judgment as of right now.
Just go to the last 2-3 paragraphs. Please go to the last page. Just hold it here, please. Para 20. Para 24, please. 25. No, go back. Go to para number 20, please. Para 21. 21. You crossed the first. 22 is your relevant paragraph. Got it. Okay.
Yeah, Your Lordship, furthermore, the council would like to state, even in Dina Bank, the court held that subsequent acknowledgements and OTS settlements can be held as reviving of limitation period.
Got it. Okay, you can close your arguments.
Thank you much, Your Lordship. To conclude, Your Lordship, once the debt and default and limitation are proved, no Section 7 petition should be dismissed simply because there's an error in stating of the date of default, and subsequent negotiations and OTS proposals do not replace or modify this foundational date, and they only acknowledge it. And the foundational date simply remains to be the non-performing assets date, as this was the first inconvertible date that proved the date of default, and where the borrower was acknowledged as defaulted his due, Your Lordship.
I think we can start. Can I just take a 2-minute break? I just need to drink some water. We'll start off with the second round thereafter. All right, team 2, you can start.
Your Lordship, just 1 minute.
Greetings, Your Lordship. In the matter of ABC Bank versus XYZ Private Limited,
Directly start off with the
the
arguments.
council is appearing on behalf of the. Much obliged, Your Lordship. I will be presenting the submissions on issue 1 and 2, whereas my learned co-counsel will be presenting issues 3 and 4, and he'll also be concluding on our behalf. Directly jumping to the submission 1, Your Lordship. My submission 1 is that the second application is indeed barred under Section 7 IBC by two main points. My first point being of res judicata and abusive process. When we look at res judicata under section level CPC, we see that there is certain essentials that are meant to be achieved in order to for a case to fall under res judicata. So, firstly, that it should be on facts, on evidence, and in relevant laws, and the main particular point being that the decision should be on merit. So, to simplify this argument, I'd like to put limelight on point 9 of the moot proposition, which particularly says that the NCLAT appeal was rejected on merit. So the question of res judicata not applying does not come in the question at all, because in the facts it is clearly stated that it was rejected on merit. Hence, this particular matter was then rejected on merit. So if we put this particular matter into the court again, it directly falls under res judicata. Since we see that there were full legal proceedings conducted twice, this was not a minor procedural issue. This was a issue that was addressed by the court, and there was finality provided on this particular issue, and all elements of res judicata are being satisfied in this, Your Lordship. I would also like to cite a case in this particular
What are the
manner, which
elements
is
of res
Sheridan
judicata?
Singh versus the
Speaker one, what are the elements of res judicata that needs to be, satisfied?
It should firstly not be barred on a technical or procedural ground. It should not. It should be on merit, and it should be in such a way that there is a decision that the court has come to after seeing all the facts, the evidence, and the relevant laws the court has applied. The court has to perform its all the duties that it is supposed to do, and in this matter, it has done so and come to the conclusion on merit twice.
Okay.
Shall I proceed, Your
How
Lordship?
so? No, not really. Sir, the court decided the matter only basis section 10A, right? That this matter, the date of default is section 10A. It did not go into what is the debt, what is the default, is the default continuous. It
Yes,
did not
sir.
even
Yes,
grant an
yes,
opportunity to the appellant bank to change that, to change the date of default. So that cannot, it's
sir. Because hmm.
continue.
Your Lordship, my entire point is that it was not a technical error. If we look at section 7 under subsection 3, there's a proviso which says that the adjudicating authority is supposed to provide 7 days to the appealing authority to give them time to make amends in their particular petition if there's some procedural error or technical error. But this was not a procedural or technical error. It was particularly dismissed on section 10A because this ground has been particularly made for those companies who have suffered under COVID-19. So in this case, the dismissal of the appeal was indeed the entire judgment that the court has given, which is on merit.
Okay, but it is not really suffered because of section 10A. No, you've been suffering because of a bad loan since 2014. So your date of default, your actual default was in 2014. Since then, you have been carrying on as an NPA. So your actual date of default is 2014 for all understanding of how date and default functions. Are there any judgments to this effect?
To res judicata pointer?
Yes.
Yes, sir. There's this judgment which is Shivdan Singh versus Daniel Kunwar, 1966. It particularly states that a dismissal of first Section 7 petition by NCLT, this is them
Can
directly
you give me the
quoting this from the
citation again?
judgment.
Can you give me the citation again?
Shivdan Singh versus Daniel Kunwar, 1966.
1966 and date of default. How is that? Is it an IBC judgment?
Well, it is about the particular Section 11 CPC. It's about res judicata particularly.
Okay, please
Yeah.
go with the facts. What are the
So
facts?
I'm stating directly, so this is actually family law case, and there was like a particular judgment that was appealed, that was given twice by the lower court and then the appellant court. I'll state the paragraph number as well. In para 20, they have stated that our conclusion on the question of res judicata raised in the present appeals is this: where the trial court has decided two suits having common issues on merit, there are two appeals therefrom, and one of them is dismissed on some preliminary ground like limitation or default in printing, with the results that the trial court's decision stands confirmed. The decision of the appeal court will be res judicata, and the appeal court must be deemed to have heard and finally decided the matter.
Okay, slightly slowly, speaker one. Can you mark the area you were referring to?
Paragraph 20, sir. Can you scroll down, the researcher? So we have a compendium if you would like to see with the
No, it's good.
particular
I thought this is good enough. Why did you stop sharing? I was not able to read it. Can you reshare, researcher?
researcher, could you reshare the screen with paragraph 20? So is the screen visible to you?
The screen is, but I don't see any words on it. It's just a black screen right now.
Um,
Okay, moving on. If you are able to share it, do share it again. Any IBC related judgments with regards to res judicata?
so it is
Just a second, let me go
the
through.
contour seeks ignorance.
And in the present case, decide all the four, including the common issues as to time. And what is the go to the para above? Yes, please. A consideration of the case item. Got it. Any latest judgments with regards to IBC and res judicata?
No, so for CPC, I've relied on old judgments.
Okay. Any latest judgment in CPC with regards to res judicata?
The latest judgment that we've relied on is of 1998, which is KK Modi versus KN Modi.
Okay. Okay, moving on. You share the citation with me.
Okay, sir. Moving on to my second point under the same submission is that it also amounts to constructive res judicata. Now, when we look at Section 11 CPC, there's an explanation for to that, which talks about constructive res judicata, which basically means that if a particular case was under the opportunity to have been pleaded earlier and was not pleaded due to whatever reason, then it is considered as to have been already pleaded. It has already considered as been decided upon. It is the law helps those who wants to help themselves. It does not wait for people to come and then particularly oblige the law to serve them again. They have been given a chance, they need to address it in that particular go. Furthermore, Your Lordship, the appealant cannot raise it later with cosmetic changes such as modifying the default date, because they're modifying the entire jurisdictional structure of their argument in the first place. And there are two judgments for this that are supporting this argument. Firstly, being Forward Constructive Cooperation versus Prabhat Mandal, which is the judgment of 1986, particularly para 20. Para 20 states that in this particular judgment, it was stated that explanation 4 to section 11, PPC provides that any matter which might and ought to have been made ground of defense or attack in such a former suit shall be deemed to have been a matter directly and substantially in issue in such suit, the point that I just mentioned. Furthermore, Your Lordship, the second judgment concerning constructive res judicata is KK Modi versus KN Modi, the 1998 judgment that I just said. In this judgment, we referred to paragraph 44, which said that the court held in this judgment that if the plaintiff has chosen to put his case in one way, he cannot thereafter bring the same transaction before the court, put his case in another way, say that he is relying on a new cause of action. So the change in the date of default does not create a new cause of action. It in fact falls under constructive res judicata under explanation 4 of TPC section 11.
Okay. You're done with this was your first issue, right?
Yes, sir. I'm done with the submission of my first issue. Now I shall be moving on to issue 2. My submission for the second issue is that the financial creditor cannot arbitrarily change the date of default, sort of continuing on my second point from submission 1. My first point under this submission is that The date of default is a jurisdictional fact and cannot be altered to cure defects. Now, when we look at Section 7 in IBC, it is no doubt nowhere specifically said that the date of default is mentioned. If the researcher could screen share Form 1, please. In Section 7, it is nowhere particularly mentioned that the date of default should be mentioned. And I agree that IBC only focuses on when the default has occurred and there should be an occurrence of default. But that CIRP procedure under Section 7 is bound to a particular proceeding, bound to a particular manner. The proceeding will be done, which is given under Form 1. The Form 1 is the form that you're supposed to file under Section 7. So in Form 1, we particularly look at Part 4.2. Could the researcher please share the screen? When we particularly look at Part 4.2, it's specifically asks for the date of default, and then it did
There's a voice
mainly
issue on
because
your end.
IBC asked default. You cannot just say that this was.
There's an audio
Am I
issue.
audible?
The audio is lagging. Can you just check if your connectivity is proper?
Am I audible, Your Lordship?
I think there's duplicity of your audio. Can you speak again? Let me check.
Is it fine now, Your Lordship?
Yes.
Are we audible?
Yes, much better.
Okay.
Continue.
So, as I was saying, that Part 4.2 specifically says, as highlighted by the researcher, the date on which the default has occurred. So the date is specific, and not only because the form specifies it, but also the date determines the limitation, where the limitation is starting under Article 137 of the Limitation Act. Because then again, whenever a default is occurred, we need to have a particular period under which the application should be filed, and that is decided by the limitation which is given in that particular appeal or that particular default. So without the date of default, the starting of the limitation period can never be determined. So given the fact that we cannot just simply
Slightly slower pace.
we cannot just simply depend on the fact that there was default, but there we also need to look at the fact that there was a date of default mentioned in the particular form and in the particular appeal that was given to the NCLAT and further to the Supreme Court.
Understood.
And
One
this,
one quick clarification. The issues mentioned in the proposition is that mentioning of date of default is mandatory or not, and you are
sir,
arguing.
there is an issue with the audio.
Audio from my end.
Not able to hear you.
Just a second.
Yeah, it's fine now. Can you repeat?
Better?
Yeah.
Okay, perfect. So, the issue that is mentioned in the moot proposition, that is mentioning of date is mandatory or not, and what you are arguing is that cannot arbitrarily change the date of default. Although your arguments are in line with the issue at hand.
So, I'm arguing that there needs to be a date of default,
There has
and
to
I'm
be.
also arguing that you cannot change it. I'm sort of mixing both the arguments together.
Got it.
Yeah. So, given that if there is no date of default, there cannot be establishment of a limitation period, and whether the filing is within the limitation period or not. So, we need an accurate particular date of default, which is given under Form 1, and it needs to be followed. There's no if and buts for this, and it needs
But
to be
see, even if we go with the previous date of default of 2014 and the subsequent letters issued by you or the financial creditors, they're still under limitation. Your default is not contested here. You are at default. That is undeniable. That's a fact. What is being contested here is whether mentioning the date of default, rather the correct date of default, is allowed or not. Because what they mentioned, as per if it was not for Section 10A, then the CIRP would have been initiated against you, basis the
yes.
first date of default. Even if they would have filed it for 2014 itself, even then the CIRP would have been initiated against you because it's under limitation. What is relevant here is how important is the date of default. With that very specific context in mind, do you have any specific judgment that the date of default is not material? It is the period of default which is material, or sorry, in your case, sorry, I'm arguing against you. That it is material to bring out the date of default.
Just a second, Your Lordship. So the judgment, which is the BK Educational Services Limited versus Parag Gupta and Associates 2019, particularly talks about the process of IBC and the way that it is conducted, and it shows limelight on the fact that the limitation period and the way that a particular filing is done needs to be very accurate. And as soon as the time begins to run, it can only be extended in the manner period in the Limitation Act. So we need to begin the limitation from the date of NPA, which means that the date is indeed essential, and there cannot be just date of this cannot be just the default occurring that is of substance to this judgment.
Yeah, which paragraph are you relying on?
So paragraph 32,
Just,
point 1.
just highlight the paragraph, the portion that you are that is relevant.
Um, in the researcher, please screen share.
Researchers, please do tell us if you are having any issues with sharing.
Can I share the compendium? Yeah. Paragraph 32.1, lower. Lower.
32 or 22?
32, sir.
Currently at 22, I believe.
That is. So can I screen share the compendium that we've made with the relevant sections of particular judgments?
Anything, anywhere will do.
Okay. I'm screen sharing.
For Bhaskar, how much time does she have?
So 2.5 minutes. I've
Okay.
paused it right now.
Okay.
Is it visible?
Yes.
Wait. This particular paragraph, Your Honor.
I only see the introduction part.
Paragraph 21.
No, you're sharing something wrong. I see some untitled document which is regards to, I don't know.
Okay. Is it visible now?
Yes.
Yeah. BK Education Services, paragraph 21, which states that the code cannot be triggered in the year 2017 for was barred. And then paragraph 27 as well.
No, that is fine. I don't know how you're placing this. Can you repeat your arguments regarding this?
Yes, sir. The way that I'm placing it is I'm arguing that the code cannot be triggered in a way that there's no date of default mentioned. There needs to be a date of default along with the fact that a default has occurred. Just stating the fact that there's a default is not viable with the facts of the case and is not viable with the process of IBC. So I'm saying
But
that.
why does the judgment say that?
So paragraph 27, it is thus clear that since the Limitation Act is applicable and Article 137 is applicable. So when Article 137 becomes applicable, we know that limitation period is being counted from that day. So the right to sue, furthermore, then makes it even furthermore of importance that the date of default is mentioned in the particular application. Otherwise, the Article
So
137
basically, you are
governing.
inferring it from this paragraph, although it's not clearly stating it.
Yes, sir.
Because this does not talk about a date of default, it only talks about limitation of 3 years. But there are plenty of judgments which came thereafter, which clearly say that it is continuous in nature if there's a further dates, like in your case, there are multiple letters which are being issued. So it becomes a continuous date of default. But with regards to a date of default being mandatory, this is not the judgment for it.
All right, so
No, no, all right. You have to either agree or move on. Uh, I don't see that any other judgments relying on that date of default not being important.
so I am arguing that the date of default is important, and I'm
Sorry,
saying
sorry.
that
You
uh,
go.
the article, I agree that we've inferred it from this judgment, but we've inferred it in such a way that if Article 137 is governing IBC, right? If it is governing IBC, then the filings need to be in accordance with the procedure that is already governing another procedure. And if it is not in accordance, then it cannot be a place to file the particular filing in the first place.
So you're reading it in consonance with Form 1, which is to be filed.
Yes, sir.
A very specific entry for. Got it. But do you have any other judgments specifically for date of default?
Specifically for date of default, just a moment. No, Your Lordship.
That's all. I think you can conclude your side of the argument. We'll go to issue 3 and
My last point being under the same submission was the doctrine of estoppel, which is a simple rule of appropriate and reprobate, that a person cannot accept or reject the same instrument at the same time. It makes an abusive process and it contradicts the IBC's objectives of certainty and timelessness. And then furthermore, I also would like to state this judgment, which is Babulal Vardaji versus V. Gulzar Aluminum Industries, paragraph 24 to 28, paragraph 30 to 33. I'll share it. Yeah. In this particular judgment, it is stated that if we look at the facts of our case, we see that the initial default was of 2014 and the filing was of 2020. Now, here, uh, there's an argument that the OTS issued in 2017 acts as a furtherance of limitation period. But this judgment provides that negotiations, OTS proposals, or correspondence documents do not reset the default date unless there is valid acknowledgement under Section 18, which was not there in one time settlement because there was no signature. The signature is essential, and one time settlements do not particularly act as an acknowledgement under Section 18. So the limitation period itself, when the application was filed in 2020, was finished. So there's no ground for the application to be filed because it is going against the Limitation Act and Article 137 of the Limitation Act.
got it. Can you go to the next paragraph page, please? This seems to be relevant. Perfect.
With that, I conclude my side, Your Lordship, and I hand over to my co-counsel for issues 3 and
Thank you.
Counsel, greetings, Your Lordship. I would like to address the issue 3 and issue 4. So, starting with issue 3, that talks about can the date of default be changed? So, first, I would like to mention the points that the appellants have said that the NPA date represents the earliest legally crystallized date of default. So that means date of default is fixed, and then they say that NPA is the foundational date of default for all the insolvency proceedings. And then
Just can you close the screen share? I can't see any of you.
Lordship is fine now.
Yes.
Yeah. And then if we see section 3, subclause 11, that states that debt is nothing but liability in respect of claims which is due, and that default is nothing but non-payment of debt when it is become due and payable. That means it occurs at only one point. Even if the default is continuing, the date of default would be the one single point. And then Article 137 of Limitation Act again says you can apply for when the right to apply occurs on the date of default. So from the date of default, you'll have a limitation period of 3 years. And then if you see, the appellants have pleaded the date of 2020 in the first petition, and then now they are claiming that the date of default is not 2020 but of 2014. If you see, their points itself contradicts their own points. For that matter, they themselves say that NPS fixed date. If NPS fixed date, why would there be two arguments based on one on 2020 and one on 2014?
What happened in 2020? What was the reason?
Sorry, my lordship.
So in 2020, on the 1st of May, there was a letter issued by the bank to you cancelling the OTS sanction. So basically, there was a OTS. So a fresh date of default did arise, right? Now,
Lordship. Hmm.
just saying that, okay, the first date of default was your NPA 2014.
Yes, my
After
lordship.
you have multiple letters throughout the years 17, 19, 20,
Hmm.
you agreed to an OTS. Once you agree to an OTS, a fresh event arises.
Yes, my lordship.
Once you fail in that OTS, a new date of default arises.
Yes, my lordship. The point is taken, but
They
the
have the
issue
right
here.
to choose which date of default to pick. If one date of default does not work, do they have the right to go back to the original date of default?
No, my lordship.
Right? So,
The council for respondents said that they cannot change the date of default.
Hmm.
And then in the case of BK Education Service plus Paragupta, it was clearly mentioned that uh, default is one-time event and that limitation starts from that event.
Hmm.
And then if we see uh, in the as the appellants have mentioned the case of Dina Bank, it says that an OTS is of a life claim made with limitation and can be acknowledged. It says that OTS is a valid form of acknowledgement. We do accept that, but it is a valid form of acknowledgement of debt only when it's happening in the limitation period. If you see, the first OTS was issued in 2017, and the second was issued in 2018, third was in 2019, and the fourth was in 2020, which was subsequently approved by the bank. The OTS which was approved was 2020, which is beyond the limitation period. So if the when
Yeah,
the
I think you're arguing it wrong. Your issue here is that can the facts and circumstances, the date of default changes. Now, just check what you have used as a issue in your memo.
just a second, Lordship.
Fiction cannot be shifted based on subsequent events. And
Yes, yes, my lordship. The point we are trying to establish here is that the section 312 also says that default is non-payable. Default occurs when the debt is due and payable, and that the section 18 extends only from the date of limitation. And that if you say the date of default was 2014, we do accept that there is a default, and that was in 2014.
Hmm.
But that date of default from that point of time, 2014, it will only be considered till the date of 2017 because the limitation period is of 3 years. So once the limitation period has crossed, any OTS made after the limitation period do not sustain it.
Do you have any judgments to this effect?
Yes, my lords. The lordship, the judgment we have referred is that of the appellant side as well. Dana Bank was Sri Shivakumar Reddy.
Okay.
In the paragraph 142, it says an OTS of life claim made with limitation can be an acknowledgement under section 18. That means any OTS which is made in the limitation period is a valid form of acknowledgement of debt,
Hmm.
but not after limitation period.
Let me get this right, okay.
Sure.
The company should, you went NPA on 0104,
Yeah.
2014. You issued letter asking for
Restructuring in
factoring in
2014.
2014, not
Yeah.
allowed.
Not allowed. Yeah.
You again
In
another
2017.
2017,
And
01,
again in 2018.
2017, 0101. So you are claiming that your limitation for 2017 14 ran out in 2017
Yes, my lordship.
and letter issued and only in OTS dated 0102 was the OTS allowed.
Yes, my lordship.
So there's no connectivity between the first date of NPA and your OTS which happened in 2020 after 6 years.
Yes, my lordship.
And 2020 they can't file it because the date of default is as per section 10A.
Yes, my lordship.
And what does Dena Bank say about this?
It says that OTS is a valid form of acknowledgement of debt, but only when it is filed in the limitation period.
Show.
Because, sorry, my lordship.
Show me the paragraph.
Sure, sure. Rizwan, can you please open Dina Bagnos Use Already paragraph number 141 and 142?
Which paragraph number?
141 and 142 to be precise.
Master, how much time do they have?
So I've paused it for now, but 11 minutes are left.
Okay.
Yes, sure. Yes.
141. Okay.
Um,
142. 141 says that OTS is a valid form of acknowledgement that we do accept, and then we are proceeding to 142.
Hmm.
To sum up, in consideration of opinion and application under Section 7 of IBC will not be barred by any limitation on the ground that it has been filed beyond period of 3 years of date of declaration of loan account to be as NPA. That
So
means, yes, yes, Manoj.
if there is a acknowledgement of the debt,
Yes, Manoj.
acknowledgement of debt is not OTS. Acknowledgement debt is all these letters which you issue.
Yes,
You are
Manoj.
acknowledging the debt in all these letters.
The acknowledgement of OTS by the bank would be a valid form of acknowledgement.
Oh, no. You have to you're reading it wrong. If there were an acknowledgement of the debt by the corporate debtor, not the
Yes,
financial
Manoj.
creditor, the corporate debtor, which is you. So if you are acknowledging the debt, which you have done through so multiple letters, which makes it be, within limitation,
Yes, Manoj.
not by the financial creditor. The financial creditor OTS would have happened post 5 years. That's why one thing I've never heard of this point of law. You have issued multiple letters every year. You have consistently issued letters. You are acknowledging the debt every time you are issuing a letter. OTS is only acknowledging that yes, we are restructuring the debt.
Yes,
But since
Manoj. But
you
that
have
was
done
never
it,
accepted by the. Yes, Manoj.
if you have done
But
it,
that the,
that means that the limitation continues. If there
yes,
were
Manoj.
acknowledgement of the debt by the corporate debtor before expiry of the period of limitation of 3 years, you have done it across. Even right now, if you file it, okay, right now might be late going in 2026, but your last acknowledgement is 01/01/2022. So till January of 2025, he could have filed a Section 7, allowing which would be within time.
Yes.
You got
But
it wrong.
pardon for the error,
Yeah.
Lordship. But even if you're going to the case by the appellant, they have stated their date of default to be in 2020 in the first attempt, and then
Have done. That was rejected.
yeah, yes, Lordship. Then I would like to proceed to the further issue.
Hmm.
Stating in the furtherance of this issue is that the case of estoppel, which my co-counsel has already been mentioned. So we state here that the date of default cannot be changed, and that it has to be one single point, which is 2014.
You're still in issue number 3, right?
Yes, Manoj. We are almost finished this one. I'm proceeding to issue
I,
4 now.
I think you're slightly off the argument here because the point here is that you could have simply argued that I'm giving you tips right now, but your argument should have been that the date of default, immaterial of 2014 or 20, because both of them are under limitation. The,
Yes,
the act of changing the date of default is not allowed.
yes, Manoj.
It is not about the limitation here, but that is, of course, issue number 4. But issue number 3 is the action itself is not allowed as per
Not
the law.
allowed. Yes, Manoj.
Now,
That is bar and estoppel.
on that very specific action, Have you any judgments from NCLT or NCLT or Supreme Court which clearly says that the change of date of default does not apply, cannot be done? Because there are plenty of judgments which say that that can be done.
Just a second, Lordship. Lordship, I'm unable to find the relevant judgment, but we would like to quote it whenever the time permits. Then
You prepared for your rejoinder.
yeah.
Uh, I think we can go to issue number 4.
Yes, my Lordship. Sure whether the day error in date of executable or not. Lordships, the we error does not violate Section 7 petition. So that such date of default is not merely a inadvertent error, but it's a main fact based on which the jurisdiction is decided. Lordship, date of default is the main matter from which the limitation starts, which acknowledges the threat, and then also whether the Section 10A would be applicable or not. My Lordship, date of default is not merely a technical or inadvertent error. It's a foundational fact based on which the case determines. So they claiming that it was just a inadvertent or technical error is not. And then, my Lordship, the next thing, we have a case in which it was V. Nagarajan versus SKS Ispat. In this case, my Lordship, the Honorable Justice D.Y. Chandrachud has said that even if you're applying for a certified copy, there must be strict diligence followed. So if just applying for a certified copy would require strict allowance and diligence, filing for a date of appeal would also need strict diligence. The date of the appellants cannot claim that for 500 crores of debt, they just made a technical glitch of mentioning the date of error as wrong. That would not sustain, my Lordship.
Have they
Then
claimed it to be an error? In the facts, it does not show to be an error, no?
the appellants have argued that it was an inadvertent error while mentioning
Which
default.
paragraph says so? Can you repeat?
My Lordship, the appellant's arguments have stated that they have clearly stated that it was an inadvertent error while filing inadvertent error that the
Just
date of
second, I'm
default they have
going to the
mentioned.
memo.
Yes, my Lordship.
57.
And they also claim that they have made a correction in the date of default.
No, but nowhere in the memo does it say that they have claimed it to be an error.
Lordship, the issue 4.1.
Issue 4.1. No, which document are you relying upon? Your own memo or their memo?
The memo and also on based on their arguments, my Lordship.
Just a second.
Paragraph 44.
Paragraph or page number?
15, my Lordship.
Oh, they used error. You're right.
Yes, my Lordship. And then, my Lordship, they have claimed that they have made a correction in the date of default. Based on which they have also cited the case of Axis Bank, where the facts as stated by the appellant were there was an application filed, then the bank got to know that there was an error. There was an error in the date of default, and after examining, they just re-updated the date of default. But, my Lordship, I would like to state here that that was in the same petition. Before the court have adjudicated the case, they have made an change in the date of default. But in present case, your Lordship, the first they have relied on 2020 date of default. They have produced all the documents related there, for Form 1. And then once the matter have been adjudicated in NCLT and NCLAT, then now they are claiming that they said another date of default. So both the cases do not, the facts of both the cases do not seem to be identical, Your Lordship, and that here the case is completely different.
Hmm.
So here it's not merely correction, but it is a foundational fact based on which the old jurisdiction changes, Your Lordship.
Understood. Okay. Thank you.
And then, Lordship, coming to the next, that we would like to state is that if we allow from the just a second, Lordship, and then in their memo they have stated that the rejecting section 7 for minor procedural deficiency is not accepted. The date of default is not minor, Your Lordship. It is as said, it is a core fact based on the jurisdiction changes. Then, as we have cited the case of B. Nagarajan, uh, it was mentioned that even if you're applying for a certified copy, you have to maintain due diligence and strict compliances with the law. So that if for certified copy is that, I think for the date of default, it should have been more diligent in the way they have mentioned the date of default. And also, Your Lordship, coming to the next point that yeah, if we allow the creditors to change their date of default after finality of an case has been incurred, that leads to abuse of power, Your Lordship, because the main fact that leads to abuse of power.
Okay.
Because Lordship, every time they had each and every opportunity in 2022 to mention the date of default to be 2014,
Hmm.
which they knew that would be after limitation, and then they have ignored it and they went to 2020 producing all the required documents. So once they have said every document is being produced and after it has been finalized, now they cannot claim back that 2014 is the date of default.
But letting you
If
go scot-free is not good, great, right, for the
yes, my
economy.
lordship, the core essence of the IBC bringing section 10A is to protect the default.
Hey,
It is
let's,
undeniable
let's
that the
let's go
default
with
is
this
there.
that you are not a defaulter who was really impacted by COVID. Section
Yes,
10
ma'am.
should not have applied on you. It's the inadvertent error on the part of the bank because of which you are safeguarded. But to
Yes,
let
your
go
lordship.
of the recovery, a legitimate legal recovery from you because of a technicality is also not right. Because
Yes, your
I have
lordship.
to know from you, and of course the facts are silent on whether I've been able to recover, attach your assets or not. 500 crore
Yes, your
recovery.
lordship.
So
This
I think this matter on purely on the basis of a technicality that they dismissed a date is also wrong because public money is involved.
yes, your lordship, but mentioning the date of default is not a technical error. It's just that if you are giving a date of 500 crores, you must be assure you the appellant must have been sure of the date of default, and that uh, they if they just have argued the point that since the 2020 date didn't work for them in the previous two appeals, they have came up with another date of default, which I think my lordship is not just a mere technical error.
This
So my
judgment
lordship,
which you are relying upon, this judgment that you are relying upon, V. Nagarajan versus SKS Ispat.
yes, my lordship.
So the what was it was basically a limitation. I'm assuming that they filed the appeal late and they claimed that they had applied for a certified copy. How is that applicable in your case?
Yes, lordship. We are just concerning with the issue, the not the fact, but the law that has been took
No,
over from the case.
how is this applicable? It is not applicable. This
My
was
lordship,
limitation in filing of an appeal, I'm assuming, and they took the defense of a certified copy, which is like the
yes,
standard.
my lordship. Yes, my lordship. We are, the facts are completely different, but the law, we can take it from that. It's just that they have
How
mentioned that. Yes, my lordship.
explain how do you borrow this?
Yes, my lordship. The paragraph says that even if you're applying for a certified copy, there must be due diligence for you. So even for applying for certified copy, there must be due diligence. Then for mentioning date of default, there must be a higher more due diligence.
Okay.
Yes, my lordship.
Any other judgment
Con-
to this effect? Any judgments with regards to
uh,
specifically date of default?
just a second, my lordship. Uh,
They're none mentioned in your memo.
Yes, Master. The memo is silent about this issue.
You can conclude your arguments. I think your time is
Yes,
over.
Master. Yes, Master. So, in light of all these facts and the arguments that we have put forward,
Read the bill. It's fine. It's fine.
yes, we would like to allow that present civil appeal has been set aside and Honorable High Court appeal, the Supreme Court should appeal the NCLAT's judgment and declare appellant second application under Section 7 to be is not maintainable under law and to be barred on rescue canter. Yes, ma'am.
Appellant team, you get 1 minute. If you have any pointers, I'll be noting them down. And after that, you'll also get a minute. Codemaster, please keep a check on that. Ready to start? You're on mute.
1 second, my lord. Can we borrow 1 minute's time before we start preparing our arguing our rebuttals?
Oh no. This has to be fast. Whatever is in your head, you have to speak. You can't make notes.
Yes, my lord. So, my lord, firstly, with the matter with respect to the point of res judicata, the party has relied on the case of Shriram Singh, which has no relevancy to the present matter. It does not deal with IBC proceedings. It does not discuss any elements of the suit that is in the current that is currently instituted before this honorable court, and therefore applying the rules of property partition to a matter of bankruptcy, the context are extremely different, my lord. Secondly, my lord, they have stated that we cannot change our date of default, and there are multiple cases in this regard which we have provided, and also which, as for your question, we can provide more. There is also the case of Vibrant. 1 second, my lord. Vibrant Central Bank. 1 second, my lord. I'll tell you the name of the case.
Vibrant.
Central Bank versus Vibrant Content, which also states the same thing, that the date of default can be amended. It also states that once the limitation period has been acknowledged by the second party or by the creditor party and the defaulter party, then the limitation period restarts, which is something that they said that was not possible. Secondly, even the one-time settlement is an acknowledgement of the fact that there has been a default and that this default does exist, which restarts the limitation process. So if it was done in 2017, it extends to 2020. If it's done in 2020, it extends to 2023. And therefore, it continues and progresses in this manner.
Done?
Yes, sir, the time is up.
Okay. Respondent?
Much obliged.
Yes, Your Lordship. Firstly, I would like to address the point that was made about the Shriram Singh judgment. As I previously said, that even though it is a family law judgment, some elements of law remain the same throughout the years of law, which particularly deals with CPC section 11, which talks about res judicata. Res judicata does not pertain to a particular law. It applies everywhere in every single appeal that is made to every single court, and it talks about the well-being of the legal system and not burdening the legal system with the same cases, the same facts, and the same bundle of point. Second point that was mentioned, that the OTS particularly gives more time for limitation, and the limitation keeps on exceeding by particular each and every OTS that has been issued. I previously stated these in my arguments as well. In the Babulal Bardarji Gurjar judgment, it is very specifically said that OTA proposals cannot be taken as a valid acknowledgement unless there is a like negotiations, OTS proposal correspondings do not reset the date of default unless there is a valid acknowledgement, and there is no mention in the fact that it's valid acknowledgement. My last point being that their entire argument is that the decision of NCLAT and NCLT was not on merit, but it was on merit, and it is given under point 9 of the new proposition facts itself. So the issue ends there when you look at the facts itself.
Done, both the teams?
Yes, Your Lordship.
I will be sharing your marks, point.